welcome everyone. I am Jeff Lewis.
And I'm Tim Kowal. In the California Appellate Law Podcast, we try to bring trial attorneys and appellate attorneys some news they can use in their practice. Both Jeff and I are appellate specialists, but we split our time about evenly between trial and appellate courts. And a quick announcement, this podcast is sponsored by CaseText. CaseText is a legal research tool that harnesses AI and a lightning-fast interface to help attorneys find case authority fast. I've been a subscriber since 2019. Jeff has been a subscriber since 2019. I've been a subscriber since 2021, and we both highly endorse the service. Listeners of the podcast will receive a 25% lifetime discount available to them if they sign up at casetext.com/CALP. And today we welcome Ben Ikuda to the show. Ben publishes frequently on issues of interest to trial attorneys. And Jeff, I thought it would be great to bring Ben on to talk about his med-mal practice. Ben has practiced medical malpractice defense for 8 years after graduating from UC Hastings in 2008, and then later transitioned to being a med-mal plaintiff's attorney. Ben beat Dan Hodes, a prominent med-mal attorney, in one trial, and Dan Hodes hired Ben in 2016, and at his firm, Ben became a named partner in 2021 after several successful jury verdicts and multi-million-dollar settlements. About a year ago, Ben started his own med-mal practice with Michelle Hemisath. Since opening the firm, Ben's firm has already recovered over $17 million on behalf of clients. Ben has published and given presentations many times on med-mal issues, including for the Consumer Attorneys of California, the Consumer Attorneys Association of Los Angeles, and the Orange County Trial Lawyers Association. So welcome to the podcast, Ben. Thanks for being with us today.
Appreciate it.
All right. Ben, if I gave a little bit of an introduction to your practice, is there anything I missed that we should cover right off the bat here?
No, nothing else. That's everything. I do med-mal. That's what I do. I'm a med-mal guy.
The med-mal guy. Now, there aren't all that many of you. I know. We talked about a mutual colleague who just found it's a very tough practice. There's a lot of attrition in it, especially for younger attorneys who see a lot of regular, general personal injury attorneys, winning nice awards, and they try to replicate it in the med-mal field, and it doesn't quite pan out quite the same. What is the secret? We know about the MICRA caps and everything. We'll talk about that a little bit more, but tell us a little bit about why you got into med-mal when it is such a tough practice.
Sure. So I started my career in med-mal defense. I absolutely loved it. I loved representing doctors and physicians in hospitals. Hated the insurance company who paid our bills, but really liked the practice. And then, as you noted previously, I switched sides to the plaintiff side with Dan Hodes. I love it here on the plaintiff side as well. It's extremely interesting. It's fascinating. And I absolutely just really enjoy it, really love it. And I represent people who really can't find a lawyer. So I'm one of the very few med-mal lawyers out there on the plaintiff side. And the reasons for that, it's a lot of reasons. There's MICRA, obviously, we'll talk about that later. But the biggest reason, frankly, is because doctors have a lot of credibility. They have instant credibility the moment they step inside the courtroom. And it's not like, suing a bad driver or suing, Walmart in an employment case. There's already an advantage towards doctors where credibility is everything. It's very hard to overcome that. And also the juries just don't feel qualified. They feel qualified to judge a bad driver. They don't feel qualified to judge a doctor who, performed a procedure they've never even heard of, right? Much less performed. So it's very difficult to win these cases. I think the overall numbers show that I think 80 to 90% of all med-mal cases that go to trial, survive MSJ, get to trial, go in favor of the defense.
Yeah, and everyone's got a doctor, and they envision their doctor sitting in the witness stand, and they wouldn't want to find give a verdict against their own doctor.
That's exactly right. Yeah, it's almost like a reverse reptile, if you will. People don't want to believe that their own doctor would harm them. It's almost like a self-preservation issue. It's very difficult in these cases.
Well, maybe we'll get into this a little bit more, but when it comes to, we have, there's been tort reform in this specific field. We have the MICRA cap in California. And it makes me wonder if there's already a bias the juries have against awarding, giving awards against doctors. Was there need for such a strenuous cap? It didn't sound like there were a lot of runaway verdicts against doctors even before the MICRA cap, or am I misremembering things?
That's exactly, well, you probably didn't remember it because it was 1975, before I was born. Really, it was the insurance companies. It was driven by the insurance companies. They made some bad investments and they wanted to find a way to save money. And they convinced the legislation to pass this MICRA law that it's not just the 250 cap. There's like 8 different laws that really are all pro-doctor, anti-plaintiff, anti-patient. And passed 48 years ago and has not risen a cent for inflation until the new year, until 2023. But it's been devastating. It's been absolutely devastating for victims of malpractice, particularly those that aren't big wage earners, or the wrongful death cases of those that aren't big wage earners. So death of a child, for example, the most you can get in that case, at least previously, was 250. Makes it extremely difficult to take these cases, particularly when there's no adjustment for inflation. My average trial cost 6 figures now to try. That wasn't the case, decades ago. So it's cost prohibitive. It makes it impossible to take these cases.
So let's just kind of finish off the bullet points of what the MICRA cap entails. So we've already discussed that there's kind of an institutional or a jury bias against giving big awards against doctors. But once let's assume that you can get over that hurdle, that bias, and get the jury to agree to give you a big award. Now you're faced with the MICRA cap. Give us the broad strokes of what the MICRA caps impose on you as a plaintiff side med mal attorney.
Sure. So the cap is, again, $250,000. It's only for pain and suffering, general damages, grief, anxiety, loss of enjoyment of life, etc. For a wrongful death case, it'd be loss of love and companionship. That's the most you can get for non-economic damages. And so again, unless you have a big wage earner, or you have somebody that's still alive and has catastrophic injuries, it's just very difficult to take these cases. So death of an elderly person, death of a child, death of a stay-at-home mom, death of a low wage earner, it really makes it difficult. I can go over my last trial if you'd like. I think it's very, very pertinent. It shows how devastating this cap is. That was a case involving, is that okay? Can I move forward?
Yeah,
okay.
Yeah, let's do it.
Yeah, so this case, I tried it in August, and I foolishly took this case. My heart broke for the family. It involved the death of a 2-year-old girl. And this little girl had at birth had a VP shunt place. It helps drain, cerebrospinal fluid from the brain into the stomach. And a well-known issue with this VP shunt that it can malfunction. It's placed or it can get blocked, and then there's excess fluid in the brain. Well, she goes to ER. She's never seen by a doctor. The PA, the physician assistant, said, "Oh, she's fine," and sends her home. Even though she came in with complaints of nausea, vomiting, not being herself, she was just really, really under the weather. And in the waiting area, she starts throwing up this pink frothing material. Her heart stops, her breathing stops. They do a code blue on her right there in the waiting area. They bring her back, the heart rate back with epinephrine and chest compressions, but she's brain dead at this point. And she dies a day later. That's a case where I was offered exactly $0, not a penny before trial. And the reason why is because these insurance companies, it's only a small handful of them, med mal. These insurance companies know the worst case scenario is $250. I can't win for millions of dollars. They want to send a message. They want to, this is so
this is a little girl who came in presenting these symptoms and then was turned away and wound up dying a day later?
Well, she went into cardiac arrest, cardiopulmonary arrest right there in the waiting room 2 hours later. She was not admitted. She was sent home. While in the waiting area, mom's filling out paperwork. She dies basically right there.
Right in the waiting room of the hospital.
Correct.
Oh my God.
I tried that case in August because they offered $0. And I didn't win that case. The jury came back deadlocked, 6-6, which in my world is a loss. And I spent $100,000 on that case. Now think about that.
Wow.
The best that I could do. It's a very expert heavy case. I have to get an ER doc, an expert PA. The best that I could do at trial is $250, right? So I get an attorney fee of what, $50,000? When I spend 100 hours of my time and $100,000 in the case, and the family ends up getting $100,000 in their pocket, the death of the little girl, it's devastating. And it just shows how difficult it is to take these cases. Those are 2 weeks or 3 weeks that I tried. Wow. I wasn't working on any other cases. Yeah. It really is devastating, and it works, right? And now I cannot take that case again in the future because I would go bankrupt if I did.
Yeah. And you haven't gone bankrupt because in the last 9 months you've racked up $17 million in victories. So tell us how you count up to 17 million in a short amount of time, facing up against that $250,000 MICRA cap.
Sure. So we have to take cases that either involve the death of a high wage earner or the death of a catastrophically injured child or person who needs lifelong dollars and cents medical care. Those are the only cases that are economically viable, frankly. And the majority of the 17 million are those cases.
Because if you can get the economic side of the damages is not subject to the MICRA cap.
Exactly right. The MICRA cap only applies to non-economic damages. But again, death of a child, you only have non-economic damages.
Yeah, children.
Hey,
yeah, that's it is macabre when you think about it that way. That a child basically is just a loser from the standpoint of the law governed under the MICRA cap.
And the jury doesn't even know about the cap. They're not told about the cap, so they can.
Oh, wow.
My very first trial on the plaintiff side, I won a child death case. Again, no surprise, no offer case, not a single cent, because they want to force me to trial and dissuade me from taking the future cases. Tried that case, won 12-0 at trial. So all 12 jurors in my favor at Riverside. And they gave me $500,000. And the judge, it was such a gut punch watching the judge cut that verdict in half,
Sure.
the 250.
Hey, Ben, California is not known for being a conservative state. It's rather blue. How is it that the legislature has left these limits in place for so long? Why hasn't there been more of a push to reform and to lift MICRA?
Yeah, the insurance companies have a lot of power, but also the California Medical Association, the CMA, has had a tremendous amount of power. And again, people like doctors, people like the physicians in the healthcare industry. They don't like these, quote, retrialers, end quote. When in reality, really there's a lot of victims of malpractice that can't find a lawyer. And when they do, they lose a trial or they don't get what they deserve because of that MICRA cap. Now, that being said, the law did change. We're going to go up in the new year. So there has been some positive change here that it really is a game changer.
Well, will that impact your decision in terms of what cases you might be willing to take?
Enormously.
Yeah. Okay.
So,
Hey, let me ask you. Go ahead.
Oh, I'm sorry. So that same child death case. So now in a wrongful death case, the cap's went from 250 to 500. However, there's more to that. Prior to the new year, there's a total of 250, regardless of the number of bad guys, regardless of the number of negligent parties. So if a doctor and a nurse both screw up, the most you can get total is 250. In the new year, that's going to be 2 different caps, and even 3 in some limited circumstances. So instead of 250, now you're looking at $1 million. And don't forget too, CCP 377.34 was changed this year, 2022, which allows for previous pain and suffering as well, which is an additional possible 700 for the survivorship action. So a 250 case could potentially be a $1.7 million case. Now, is that justice for the death of a young girl? No, but it's certainly a step in the right direction and make these cases at least viable.
Do you think settlement company, the insurance companies will be a little more interested in making decent settlement offers before trial with the caps lifted like that?
Yes, I absolutely do. I think the attitude of no offers at all, 0 offers, and forcing the trial, that will be less common. Because again, the 250 number is such a devastating number because I cannot make a profit. I cannot stay in business if I took those cases. I just wouldn't. Now with the cap going to 500 for a wrongful death case, now I actually can possibly make a profit if I win the case. So it is a game changer. Absolutely.
Yeah. Well, yeah, because you have to fly your X-wing down through the little gully of the Death Star and file those little torpedoes into the exhaust chamber, all for not to blow up the Death Star, just to get $250,000. I mean, it's just no one's gonna take that gambit. But now, if you got more people who, if you start doubling, tripling, quadrupling that, it's still, like you said, it's not going to be justice, but you may have more people, more med mal plaintiffs who are willing to take the gambit. And just being able to get your foot in the courtroom, through the courtroom door is, I mean, that's at least what we call the definition of justice. You get your day in court. Whereas a lot of people may not even be getting their day in court. They can't find a med mal attorney to take up 6 figures in costs just to get to a near guaranteed loser.
Exactly. We at our firm, we take 2% of cases that come in the door, which actually is much higher than most med mal firms.
Wow.
My old firm took less than 1%. We take 2% according to our stats here. And a lot of those cases are legitimate cases that we simply cannot take due to the MICRA cap and the costs of litigating these cases. And so with the new law change, certainly that will go up.
Yeah.
Wow. Hey, Ben, early in our conversation, you identified two ways that the deck was a bit stacked against you in terms of jurors' belief in doctors and their feeling of not understanding or not being qualified to understand things like medical causation and that kind of thing. What are the techniques that you used that you've used successfully with a jury to overcome those two issues, the trust issue in terms of doctors and educating a jury to understand these medical issues?
Sure. The most important thing that a trial lawyer needs to do on the plaintiff side is to dumb it down. You need to make it as simple as possible. You need to make sure that a sixth grader can understand what you're saying. And so the defense does the opposite. I mean, as a defense lawyer in med-mal, I was trained to do the opposite. Make it as complicated as possible. Make it so the jury just throw up their hands in the air and say, I don't know who's right. It sounds like we have two good experts. I'll call it a tie, and then the defense wins ties, right? So, the key is to dumb it down, make it as simple as possible. I also make a lot of comparisons to auto cases and to explain that negligence does happen in the operating room. To explain that these doctors are human, they make mistakes, sometimes unreasonable mistakes. But again, I think the biggest issue is to make it as simple as you possibly can so that a jury can understand it. I also think it's extremely important you show demonstratives, that you use visuals, you have your experts draw to show a jury. Most jurors, most people are visual learners. It's also very, very important in the courtroom. That's how I do it, at least.
How important are experts and expert battles in med-mal lawsuits?
Enormously important. Yeah, you don't have a case unless you have an expert. And that's a big challenge there too, right? It's not hard for these defendants and these insurance companies to find experts who are supportive of their colleagues. It's much more difficult to find experts who will go out on a limb and be critical. But yeah, the experts are enormously important. It is oftentimes a battle of the experts. And so getting a well-qualified expert who's,
does the defense side often put up a big fight to try to exclude the plaintiff's experts?
Yes. Well, yes. Generally, yes. Not with me as much. I mean, I absolutely try to get the best experts in the field. A lot of times, you don't want a general practitioner, commenting on OB/GYN care, whatever. So it's important you have an expert in the field. It's extremely important. Otherwise, you will be facing a motion to exclude experts. But for me, I tend to try and get the best.
Yeah. Do the same experts make appearances in a lot of your cases, or if there's a lot of subspecialties, does it mean that there's always going to be a different expert?
Yeah, so you need to get an expert in the specialty that you're suing. If you're suing an orthopedic surgeon, you need an orthopedic surgeon. If you're suing an OB/GYN, you need an OB. But it's not uncommon to see same experts. And in fact, like the trial I was mentioning earlier, the trial where I mistried or I had that deadlock jury, the expert against me was an expert testified for me in the trial previous to that. So It's not uncommon to see the same basis in trial.
Yeah. Is it hard to find someone who is an expert who has the qualifications you want, who is a true expert in his or her field, but can also speak to the jury? You mentioned that as the plaintiff, you want the jury to be able to understand you. If you're the defendant, you just want, probably the more jargon, the better. If you can go over the jury's head, that almost guarantees a defense verdict. But you want an expert to be able to make it understandable to the jury. Is that hard to find?
It's tough. It is hard. It's a fine line, right? You want your expert to seem intelligent, know what they're talking about, but also to dumb it down enough so the jury will understand it. And the show is not just a judgment call. I lose those cases, right? A judgment call or discretion by the doctor. I lose every one of those cases. You have to show they truly acted unreasonable. They acted below standard of care. That any other reasonable doctor would not have taken that same approach. So yeah, it can be tough. But they're well versed in trying cases or testifying in cases, and we do prepare them a lot before trial. So
yeah. Now, Ben, you had mentioned that you're familiar with our episode that involved Brooke Bove. She was the attorney who wrote the successful motion for new trial, and what we refer to on the podcast as the victory bell case. That was the case where there was a defense verdict in a med mal case, and the trial attorney on that case, by the name of Robert McKenna, had gone back to his office where someone had videotaped him on a cell phone and made it available online, where he had mentioned that we won that case by sort of making it look like someone else did it. Although what did he say? That it probably was negligence, but we sort of made it look like someone else did it. And we haven't said anything, beyond just quoting or paraphrasing what happened in that case. But I understand you may have crossed paths with Mr. McKenna at some point in the past.
Yeah, no, I like McKenna. I used to work for McKenna for several years on the defense side. I'm underneath him, and then since then I've had cases against him, quite a few cases against him in this firm. I like McKenna. He's usually a very upstanding and straightforward guy, and I was a little surprised to hear those comments, but I think it does show the difficulties we have in med mal. I mean, you have a case where even the defense lawyer knows it's malpractice, and a jury came back in 26 minutes with a 12-0 verdict. So no, Robert, he's a trial lawyer. He likes to boast. He likes to brag. He likes to tell stories, and I think he was boasting and bragging in that video. If you watch the video, it's actually a laptop in front of him. I think his LA office. He's in Orange County. His LA office was watching while he was, touting his trial victories.
Oh, wow.
And I think he was definitely just bragging and boasting. I actually looked at that exact case, before it was filed to see whether or not we should take it. And we decided to pass on that case. I thought there was malpractice in that case, frankly, the inappropriate or improper insertion of a G-tube. But a case that was capped at 250 would be too difficult to try and too difficult to win. I ended up being right, clearly. But I know Jorge Ledesma too, the plaintiff's lawyer. I like him a lot, respect him quite a bit. And obviously, Brooke Bove did a fantastic job on that motion for new trial.
Yeah, I did think that was an interesting backstory, the way that Brooke was able to get that verdict reversed, because there was, as we pointed out during that episode, there were a lot of commentary from those of us in the peanut gallery who didn't know any of the inside information about the case. That, oh, well, how would those comments may be untoward, but how are they going to relate to a new trial motion? But apparently there had been this instruction about an empty chair defense, and I guess Mr. McKenna had said there's not going to be any empty chair defense, Your Honor. And so that video indicated that maybe they had been kind of sub rosa angling at an empty chair defense, and that was what the jury had picked up on. And so the judge did not like that.
That is frustrating. Can I just bring up a kind of a tangential point here? As med mal lawyers, we're often forced to sue more than the primary wrongdoer in a case, because these defense lawyers in med mal, they really try to look for the empty chair defense at the beginning of the case. Who else can we blame other than our guy, especially when there's bad results? And we're almost required. I mean, it's malpractice arguably not to include these other peripheral defendants, so we force them to file an MSJ, and then we get the protections of 437 CL, where now they can't attribute fault, they can't blame the empty chair. But it's unfortunate that we have to drag doctors into losses that don't deserve it. And the McKenna case is a prime example why.
Yeah.
Hey, let me ask you, what you worked for the guy, what would he say, or what would other defense lawyers say is unique about the way you practice law coming up against you as a lawyer? What makes you different than all the guys on all the billboards up and down the 405 freeway?
Well, I mean, frankly, those guys on the billboards don't do med mal. And in fact, most of them refer me those cases. I get a lot of those cases from refer to those billboard lawyers, but I'm extremely prepared. The most important thing is to get an expert before you even file. Before you even consider filing the case, you have an expert supportive of not just standard of care, but causation as well. So, for example, if you have an oncology, you have a case where I don't know, mass is not read appropriately by the radiologist, I will have both a radiologist and an expert oncologist who will be supportive of my case before I even file the case. Reputable physicians, and they know that. These defense lawyers know that if I file a case, I have the goods. I have the expert to support the case. I'm also very, very thorough. I know med mal extremely well. I know what's often not produced in discovery. I will ask for, PMQ depositions on incident reports, on stuff that may or may not be covered by the Evidence Code 1157, which is peer review or quality assurance. I will go above and beyond. I will uncover every stone that I know about that I didn't know.
Got
Yeah,
it.
well, and
Sounds
that
like
also-
a guy sounds like somebody who doesn't like to be surprised at trial.
Exactly. Absolutely correct.
Yeah. Well, and if you've retained an expert or multiple experts before you've even gotten a case number, that means that you've got significant hard costs already before you even get a case number.
Absolutely. It's not deep in the five figures before I can file a lawsuit.
Yeah. Well, and does that, and yet you mentioned that in a lot of these cases where you're facing the MICRA cap and you don't have a lot of economic damages on the other side of it to get around those MICRA limitations, you may have just a dead bang winner, and you still might not get a settlement offer before the verdict.
I mean, we've had to litigate cases where they poured acid instead of solution in a woman's ear. I've had to litigate cases where they operated on the wrong leg. I mean,
Wow.
cases don't settle easily. They
Wow.
look at the ringer here. They want to dissuade me from taking the next case, and
Wow.
so it's difficult. I mean, I've less than 5% of my cases settle pre-litigation. Far less than.
Yeah.
Hey, let me ask you, one of the things I enjoy about meeting guests on our podcast is not just learning about substantive law, but how they manage their practice, how they run the business of a law firm. And I understand you have a remote office. Everybody works remote. Tell us about that, your decision to do that, and how it is you're able to keep an eye on all the pieces and all the moving parts of litigation remotely.
Sure. So we started a firm, about a little less than a year ago. And I was a partner at my old law firm, Hodes Millman. Love those guys. They're fantastic trial attorneys, but they're a little bit older, a little old school in their ways. And we had a fundamental disagreement regarding how a law firm should be run. And so I started this firm. We have 4 lawyers, we have 4 paralegals, we have 2 intake coordinators. We're pretty large for a plaintiff side ML firm, but we're completely remote. We do not have a brick and mortar office. Frankly, it's been wonderful for a lot of different reasons. We have a huge competitive advantage when it comes to hiring staff. We hired 2 paralegals away from the defense side because they didn't like the idea of working remotely. They don't have to get ready for work and drive to work, which can take hours out of your day. One of our paralegals starts at 6 a.m. and she's done by 2:30. She loves that. So it's really helped us get a competitive advantage. And frankly, the pandemic has made huge, enormous strides and changes to our legal industry. I mean, could you imagine arguing an MSJ?
Yeah.
Let's say you need competitive ruling and you argue an MSJ. Would you ever appear by phone for court call 5 years ago? Of course not. But now it's standard to appear remotely to argue an MSJ or even an appeal, right? So depositions have been taken remote. It's really helped a lot, and frankly, just costs. I mean, that's $250,000 a year that we're saving in costs that we can now pass to our employees. So it's helped tremendously. And all the service now is by email, but not by mail anymore. So it's really wonderful. We work out of a center called Justice HQ, which is like we works for plaintiffs lawyers. It's a wonderful organization. We can rent offices, we can rent conference rooms, depositions if necessary.
So you have kind of a home base for an office center if you do need conference rooms.
Exactly. Yeah, it's been great. It's been a game changer for us. It's been wonderful. And frankly, we have every day we have a Zoom call. We can touch base with our employees. Obviously, we receive all their emails. I mean, frankly, I think the Generation Z and the millennial generation, they work more efficient from home.
Have you noticed any downside on the the firm culture aspect of things? If you're not interacting in person every day, do you feel that you say you have daily Zoom conference calls? Do you think that bridges enough of the gap, or do you do other things to promote firm culture and interaction?
Yeah, so once a month we do a firm day. We did last month, we did an escape room. This Thursday we're going to Osprey Farm for the firm. We do a firm day. We take a day off and just take our staff out, something nice, rent a movie theater, go boating on a lake, just different activities that we do to keep team morale up. But
you do that on a weekday, on a work day?
On a weekday, yes. So they love it, obviously.
Yeah.
They're looking to be paid. But I think it just helps morale. And just, I think it's a good look too. We want to treat our employees well, we want to pay them appropriately, we want to show that we care, we want them to feel involved in the firm. And so They love working from home. It's great. It really is for everybody.
Yeah. Well, and tell us a little bit. You talked a little bit about the economics of a med mal case. But you came from a med mal defense background, which is a lot easier to pencil out, right? If you're doing hourly, I assume that's mostly hourly work, right? But when you move to the plaintiff side, and you're taking these on contingencies, you're dealing with the cap, and you're the capped amount and lower likelihood of prevailing. Was it hard to figure out how to make that pencil out when you start a new practice, your own firm? That's got to be it's got to be a little bit scary, wasn't it?
Yes.
Yeah.
Yes, very scary. And frankly, I think even compared to other personal injury firms, in med mal, our income is so variable. It really goes up and down. Every case is litigation. We don't sell the cases pre-lit. We don't have a steady stream of income. We can make a good amount of money 1 month and make none the next month. It is very stressful. Part of the job, part of the business, and that is one of the barriers to entry. You need a lot of money too to fund these cases, and it makes it very difficult. So, absolutely, the defense side obviously doing per hour, a steady paycheck. On the plaintiff side, yeah, it's especially med mal. It's very up and down. It can cause a lot of stress.
Hey, Ben, let me ask you this. I do a lot of defamation work on the defense side, where somebody's filed a lawsuit, usually to shut somebody up for making online statements. And the cases sometimes settle. And the other side, the person who's sued, usually insists on a confidentiality clause. I hate confidentiality clauses. I wish I could have every client just refuse it out of principle. What is your view on confidentiality clauses in medical malpractice with doctors who maybe shouldn't be practicing?
I hate them so much. Part of what I do is not just to help my clients, it's to try and create change, right? And I've seen change. You want to see a change in the hospital system, especially those cases where the breakdown in the system. They don't report a critical test to a patient or other problems there. You want to make it public. You want to be able to talk about it. But my obligation is to my client, not to the public at large. And so the defense firms will insist. In fact, even before going to mediation, they'll say, we're not even going to go unless you will agree to confidentiality if we reach a settlement. So almost all of my cases, especially involving doctors, involve confidentiality provisions. It's extremely frustrating. It's unfortunate. But again, I don't see an easy way around it.
Yeah, interesting.
And that's different from elder abuse cases, right? I think you had Kowal a few months ago, where there actually is a code, a CCP code that says, we have a policy. We don't want these settlements to become, private. We discourage confidentiality. That does not exist in med mal cases.
Yeah.
Doctors don't want to lose business. They don't want to lose reputation. So oftentimes, not often, almost always, you have to agree to confidentiality.
Let me ask you this question. If we talked about how you used to work on the defense side of med mal cases. Now you're your plaintiff side. If one of your former if a hospital or insurance company came to you and said, we know you know both sides of this, and you're operating at the top of your game, would you be willing to serve as our defense attorney for some of our upcoming med mal cases? No.
No.
You're done.
Hard pass, huh?
No, yeah, I love the plaintiff side, and not just representing victims of malpractice. I also love the collaboration on the plaintiff side. Especially med mal. Not many of us, but we truly are friends on this side. The few med mal lawyers that we have in California, we work together, we collaborate, and there's a kind of a rule there, unwritten rule, that we don't do defense work if we're doing part of these groups. And so,
Right.
No, you don't cross the aisle, huh?
No, I will not cross the aisle. I don't want to be conflicted out in future cases as well.
Yeah.
I have a really bad doctor, really bad hospital. I don't want to be conflicted out when they do again commit that malpractice to different victims. So no, I will not work on the defense side.
Yeah,
those days are long behind me.
Was there a moment in your practice as a defense med mal attorney that you felt that you were working for the wrong side? Not to be a black and white about the thing, but was there a change in ethos in your own mentality?
Yes, absolutely. On the defense side, certainly we saw frivolous cases that shouldn't have been filed at all, totally meritless. We saw cases where my doctor made a mistake, unreasonable. They should settle the case, but it was a one-time mistake. There were a few, maybe 5% of our cases where we saw the same doctor over and over and over again, and they were not changing their practices. They were literally killing patients, and just a total menace to our system. And they were getting off over and over and over. I was helping them get off, by making micro arguments and timeliness issues and technicalities and simply winning cases because, for a doctor, prior malpractice lawsuits and prior malpractice issues are not admissible at trial. They're not. So you're only looking at one case only, and you still win those cases in front of a jury, even though, absolutely there is malpractice there. So dealing with those few bad apples, yeah, it was tough. It was really, really hard working on the defense side with representing those few doctors that truly were bad doctors.
Yeah.
Hey, Ben, I'm not pushing my services on you, but I wonder, in big money cases, big dollar cases without caps, do you ever consider using an appellate attorney to sit in as an embedded appellate counsel to watch the trial, make sure you're dotting the I's and crossing the T's and protecting your verdict?
Respectfully, no.
Yeah, that's okay. Most don't.
Medical malpractice is so. I know most of the law in medical. And I'm not saying I know more than an appellate attorney. I certainly don't. Okay, but when it comes to med mal, you have to know MICRA at the back of your hand. You have to know the jury instructions, 505 and 506. You need to know all those different intricacies of med mal law. And so, because it's such a hyper-focused technical area, I'm not sure if an appellate specialist sitting next to you would be helpful.
Are you telling me that when you lose, and I'm not saying you do lose, but on those rare occasions when you lose, it's more fact-based than legal-based? The jury just didn't believe your guys as opposed to a jury instruction or a legal error?
Yes.
Yeah. Okay, that makes sense.
It's more on the fence. It's not a legal error. I will say this, it's very unfortunate too, but this is absolutely true. A lot of times, so in med-mal cases, when there's no consent in the defense, no matter how bad malpractice is, if the insurance company doesn't want to settle the case, they'll always send a 9-8 offer for $0. And they'll submit a memorandum of cost for an enormous amount of money after I lose the case. Tens, if not hundreds of thousands of dollars in a 9-8. And for me, I oftentimes am put in a position where I almost have to agree to waive my appellate rights in exchange for a waiver of their cost bill. So that's the reality of med-mal, and it's very unusual where we'll actually go through an appeal for that reason. It's just too expensive too. We have to hire appellate lawyers and everything else. Even if you do win the appeal to try the case again, it just becomes cost prohibitive in a capped case. It's just not viable.
Yeah, that makes sense.
All right, Jeff, did you have a case that you wanted to talk about?
Yeah, let's shift to the tidbits part. Boy, Tim, imagine you have your kids and you're going to take them to a Laker game or a football game, and at the metal detectors, security takes you aside and say, I'm sorry, Mr. Kowal, we're not going to let you come in. Your kids can come in, but we're not going to let you come in. I read this story about something that happened back east involving the Rockettes, and a mom who took her kid as part of a Girl Scout activity to Radio City Music Hall. And the management company had set up face recognition software so that any lawyer affiliated with any law firm that was actively litigating against the management of the Radio City Music Hall, which is Madison Square Garden Entertainment, would be automatically barred from entering. This story surprised me on so many levels. The privacy issues in terms of facial recognition, a kind of a public venue, and booting a lawyer who, by the way, wasn't even working on the case, just happened to work for that law firm. I came across the story and I thought you and Ben might have some thoughts about it.
Yeah, this is the panopticon. The cameras are everywhere, and I remember the old signs. I don't see them that much these days anymore. We used to go into a restaurant. It says, "We reserve the right to refuse service to anyone." And I always wondered, are they? I thought they were just kicking out the homeless people who would come in, and they put up those signs for, just for cover. But that takes it to a new extreme. Just
lawyers
we're going to kick you out.
Lawyers are warriors for justice. They should be given box seats. They're the heroes of our community. They shouldn't be denied entry. They should be greeted with flowers and chocolates at the
Yeah,
door.
I don't want special treatment. I'm not asking for special treatment, just not negative treatment either.
Anyway, that story caught my eye, and I thought I would throw it by there.
Yeah, but no, I agree with you that this is yeah, it's we talk about access to justice a lot, but somewhere downstream there's an access to justice problem, isn't there? If you're denying services to people who represent certain causes or persons, that becomes a problem for our society. If we start vilifying, it's kind of the who is Shakespeare's character, Dick the Butcher, who said, "First thing we do, let's kill all the lawyers."
Yeah.
So we're not exactly killing them. We're just going to start denying them certain access to services and products and things if we don't like the persons and causes they're representing. It seems a problem to me.
Yeah, big time. Imagine that daughter and that mom in that conversation. Mommy, why won't they let you in? Well, mama's got to make a living. I mean, it's it's a problem.
Yeah.
Yeah.
Well,
that's
okay.
all I had for tidbits today.
Yeah. Well, let me ask Ben one other question med broadly speaking about tort reform generally. We talk specifically about MICRA, the tort reform on med mal cases. I wondered if you had, and you certainly have opinions on those, and we talked about how maybe there's some counter reforms that are going to be enacted this next year that may relieve some of the burdens that the MICRA law has put on plaintiffs in your field. I wonder if your work and struggle with the tort reform in med mal cases has given you any broader perspective on tort reform generally, like on there's product liability, or there have been people who've talked endlessly about the tobacco cases, and some people think that it was a black eye for the judicial system, that just a lot of attorneys got made rich out of the tobacco litigation. Even people who don't hold any brief for the tobacco industry think that the judiciary provided a pretty good payday to a lot of well-heeled firms litigating against the tobacco companies, and that was kind of I guess every industry is a little bit different when it comes to different kinds of tort reform. But I wonder if you had any broader takeaways on tort reform in the judicial system more generally, or if your work is more specific on med mal.
I'll just say that we have juries for a reason, right? It's the Sixth Amendment for a reason, and it's, in my opinion, the best system in the world. Other countries are copying our system. Why would we take away the power from the jury? Why would we let the jury is there to decide whether or not there was wrongdoing and the amount of damages that resulted from that wrongdoing? And to take that away from the jury, it really is, I think, weakening our entire system. It degrades our entire system. So I think tort reform it goes directly against our entire jury system.
Yeah, we have the jury system, and then we have the judge can work the brakes. If the judge feels that the jury has that the judge is dealing with a runaway jury, the judge has the opportunity to pump the brakes a little bit. So do you think that's enough in the main, that the legislature shouldn't step in too onerously to restrict that basic framework that we have?
Absolutely. The 13th juror is there for a reason as well, as kind of a safety parachute, if you will. There's no reason to take away, and as you know, and this is especially true in med mal, I mean, you're only seeing the outliers. You see these big, huge, enormous verdicts in the papers, and these facts that are, that aren't always accurate. I mean, the McDonald's coffee case, for example, right? I mean, it's not a true representation of what's happening. You're not seeing the $5,000 verdicts. You're not seeing the defense verdicts. I mean, yeah. Well, why take away the jury's rights? Why take away the power from the jury? Why degrade our entire system? Tort reform, it's bad for everyone.
Yeah, we all of us attorneys who have worked a jury or worked on a jury case, we go through the exercise of explaining to the jury the important role that they play, and then at the end of the process, we thank them for their service. It's one of the most important things you can do as a citizen is to sit on a jury And sometimes these reforms, like you say, maybe they take too much of that role away. When the jury is in any danger of actually doing something that will help society, we take away that and limit that role.
Exactly right. And it's particularly true in medical malpractice, where we see the same doctors, same hospitals over and over and over again, harm more and more patients in the same exact way, because there is not just compensation. There's not that incentive for them to change.
All right. Well, Ben, thank you again for joining us today. This has been a really fun conversation. I wish you continued success in your practice. And Jeff, that's going to wrap up this episode. We want to thank Case Text again for sponsoring the podcast. Each week when we include links to the cases we discuss, we use Case Text, and listeners to the podcast can find a 25% lifetime discount available to them if they sign up to Case Text at casetext.com/CALP. That's casetext.com/CALP.
And if you have suggestions for future episodes, please email us at info@calpodcast.com. Or if you're a medical malpractice defense lawyer and you want to come on to talk about the benefits of MICRA, give us a call. In our upcoming episodes, look for tips on how to lay the groundwork for an appeal when preparing for trial.
All right. Thanks, everybody. Thanks again, Ben.
Thank you so much. Appreciate it.
You have just listened to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. For more information about the cases discussed in today's episode, our hosts, and other episodes, visit the California Appellate Law Podcast website at calpodcast.com. That's calpodcast.com. Thanks to Jonathan Caro for our intro music. Thank you for listening, and please join us again.